Welcome back to the Business Immigration Benchmark. I'm your host, Laura Blanears. Today we're chatting USCIS adjudication trends. Of course, there are a tremendous amount of immigration headlines in the news these days, but today we want to be focusing on practical global mobility program impacts. And those impacts are going to be lying with U.S. Citizen Immigration Service and what's happening with employment-based sponsored petitions. So we'll get right to it. We've got some good news, we've got some tough news, and then I've got a nervous prediction. So let's start with the good news, start on a good note here. The good news is I have filed a handful of I-485 adjustment of status. And, I'd like there to be more, but with the retrogress dates we're seeing in the employment-based categories, even for all other, meaning folks born in countries other than India and China, they are retrogressed for EB2 and EB3 these days. So tougher to even get to the filing stage for I-485 for across the board for clients. But when I have filed, it's taking 6 months for adjudication. So that is tremendous news. So we've just received 2 green cards. We filed these individuals back in October, mid-October, and we are recording mid-April. So right about 6 months, we saw approval. Couple things to keep in mind. These folks have priority dates that are current for final action. So at the time of filing, they were current for filing when the visa bulletin was permitting dates for filing the Chart B or the more favorable calendar. And then their date did become current for final action. And so we saw 6 months from time of filing to approval just this week. So very exciting news. I think if you go on USCIS's website and you look at their average processing time for employment-based adjustment of status, you'll see that the most favorable processing time is 13 months. You'll see it also ranges to like 34 months. So quite a range. I suspect some of those dates might be reflecting folks that were eligible to file on dates retrogress. Of course, USCIS on the website does not disclose like how they're coming up with the numbers, but that's all to say, if you have a final action, we're seeing those cases when filed for 485 approved within 6 months. So congrats to my clients. It's really great. Love getting to this milestone for them. Moving to the tough news or a tough pill to swallow is the adjudication trends for national interest waiver. Now, I spoke about this previously on a previous episode some months ago, but the door for national interest waiver approvals is effectively shut. Now, in the past, under early Biden administration, so 2021 through 2023, we were seeing really favorable adjudication. We saw Biden release a memo relating to industries in the national importance that were leveraged heavily for successful national interest waiver. As a reminder, the national interest waiver is a workaround for individuals and companies to work around the test of the U.S. labor market. So individuals can self-sponsor, and in the last few years, companies were very interested in supporting national interest waiver, unlike before, because of layoffs and the tough labor market. Companies were very interested in supporting these types of petitions where historically companies really moved through PERM, and PERM wasn't taking so long. But now we're seeing a monumental shift in the interpretation of how USCIS is adjudicating the 3 prongs in the national interest waiver. Let me break them down. So the first main prong in the national interest waiver is the proposed endeavor, what the foreign national is working in, the area they're working in. It has to have both substantial merit and national importance. And in some recent denials, I see that the USCIS acknowledge that the foreign nationals' work has substantial merit, that it is an area that does prove this piece. However, that there's not substantial evidence that the work has national importance. And what the government really is looking here to show, or what they say the individual or the company must prove, is that there is some sort of national impact. And especially when someone's working in industry, this becomes really difficult because what we see the government do here is say, like, there might be great financial impact to the company, whatever product, patent, process that they've developed that's really innovative, that has substantial merit, only benefits the company. So finding evidence that provides persuasion to the government seems almost to not exist. For example, the most recent denial we had was for a very qualified individual with a PhD in artificial intelligence machine learning, co-founder of a tech firm that's receiving successful rounds of funding and is for workplace safety. Her work is implemented at ports of entry, actually, to prevent accidents and things like that. And we even had letters from the end user saying how it impacts, safety at their business and how it impacts worker safety. That wasn't enough to show the government national importance. So it feels like this standard is almost unachievable. The second prong, of course, is that the foreign national is well positioned to advance the proposed endeavor. This one, despite showing not only a progress within this woman's career, showing again, co founding the startup, that didn't win this argument. It just seems that the government here is just looking to conclude that they don't have it, and there's not even suggestion of what evidence would need it. Very disappointing. And then the third prong, which is often where we were seeing some close cases denied in the past, now is just wholly discretionary. This is on balance. It would be beneficial to the US to waive a job offer or move through the labor certification process. So this is really where USCIS holds all the cards and where we saw denials in the past. Basically, they just say, well, if you didn't really strongly prove the first two prongs, we're going to deny it on the third. And of course, in the example that I'm describing today of a recent denial we had, because we didn't prove the second prong, then of course the third prong fails. So that's all to say that as a global mobility leader, if you're listening, national interest waivers is not going to save your PERM program. So if your PERM have been on life support because of layoffs, unfortunately, you're going to have to resuscitate that PERM program. Those people are going to have to wait, which means you're probably going to have to look for international rotations or be very creative with how you avoid gaps in work authorization. Finally, moving into my sort of nervous prediction here, speaking about PERM programs, many tech programs with layoffs, and we're seeing continued layoffs in Q1, Q2 of 2025. The PERM programs are really difficult in light of layoffs because, of course, if you have laid off US workers, it complicates the ability of the company to then test the US labor market and sponsor a foreign national for a position if a US worker was laid off in a similar position in the area of intended employment for the foreign national's job offer. So, without getting too technical, layoffs really complicate the ability of a company to sponsor PERM for foreign national employees. And I think, with NIW closing, it's going to put a ton of pressure to make your PERM program work. That in combination with what I'm predicting will be a tough political environment, given the Trump administration's clear support for protecting US workers. I think the Trump administration is really going to scrutinize large PERM programs to ensure that not only are they meeting all of the requirements of the Department of Labor's certification program, but also beyond that, there might be litigation. Again, we saw this in the first Trump administration. It is very likely, and they are very clearly signaling that this is their intent. Maybe not specifically for PERM program, but they're signaling that it's the Trump administration's intent to protect the US worker. And one avenue to do that is to scrutinize how companies are or are not supporting foreign nationals for permanent job offers. So without getting too bleak, I think, we're still seeing other industries outside of tech, companies that I support are still moving forward with their sponsorships. We're still seeing movement both inbound and outbound. We're seeing robust sponsorships throughout industries. So it's not all bleak for global mobility, but I do think it's a tough era. And we did see this in the Trump 1.0. It rolled out differently in Trump 1.0, where we saw the hire American, buy American. We're not seeing those types of pushback from USCIS. H-1Bs are still moving smoothly so long as all the documentation and evidence are there. In fact, we are moving more to online filing and seeing great success there as well. So it is a tough time right now to be an immigration attorney. It's a tough time to be in the immigration field. I think while I have some difficult, nerve-wracking predictions, I also think that there are processes that are still moving smoothly. We are still seeing green cards being issued. So there is a light at the end of the tunnel here. And hang in there for all my listeners and reach out if you've got any feedback, questions, thoughts for future episodes. Thanks for joining me here on the Business Immigration Benchmark. We'll catch you next time.